Kosovo Specialist Chambers is now in session. Please be seated.
Good morning and welcome everyone in and outside the courtroom. Mr. Court Officer, could you please call the case?
Good morning, Your Honours. This is file number KSC BC 2020-06. The prosecutor versus Hashim Thaci, Kadri Vaseli, Rajab Salemi, and Yaqub Krasniqi.
Thank you, Mr. Court Officer. Now I kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor. Or Madam Prosecutor.
Good morning, Your Honour, and to those in the courtroom and joining remotely. For the Specialist Prosecutor's Office this morning are Specialist Prosecutor Jack Smith, to my right Alan Teager, Senior Prosecutor, behind me David Harbuck, Prosecutor, and to my left Marlene Yahahaga, Disclosure and Legal Officer. And I am Claire Lawson, Head of the Legal Office. Thank you.
Thank you very much. Now I turn to the defense. I will call the lead counsels of each accused as they are reflected in the case name, starting with counsel for Mr. Thaci, then counsel for Mr. Vaseli, then counsel for Mr. Salemi, and then counsel for Mr. Krasniqi. May the lead counsels introduce themselves and their team, and I will start with Mr. Hooper, please.
Good morning. David Hooper, lead counsel, and I'm joined today by Dastid Palaska, who's on video link there, and by counsel Sophie Menegon, who's in court. And yes, thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
This is Ben Emerson on behalf of Kadri Vaseli, and I am representing Mr. Vaseli jointly with Kosovo counsel Kwitim Kiraveshi, who is watching remotely.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, may it please you. My name is David Young. I am a counsel from England. I'm the appointed lead counsel for Recep Salemi. My co-counsel will be Mr. Geoffrey Roberts, and if I may introduce my legal advisors, who will be Dr. Rudina Jassini and Fortuna Sheremetti. Thank you.
Thank you, Mr. Young. And finally, Ms. Alejandra, please.
Your Honour, Venkateshwari Alejandra, counsel for Mr. Krasniqi, appearing together with co-counsel Mr. Aidan Ellis.
Thank you, Ms. Alejandra. For the record, I note that Mr. Thaci, Mr. Vaseli, Mr. Salemi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. And for the record, I am Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, I would ask the parties to adhere to the following rules in order to make courtroom proceedings smooth. Please talk slowly and clearly, and wait 5 seconds before responding to me or a party or participant in order to allow the interpreters to finish interpretation. I also inform everyone that 6 counsel are participating in this hearing via video conference. In order to allow everyone to follow the proceedings, please do not speak at the same time and wait to be given the floor before switching on your microphone. I am sure many of you are now familiar with Zoom, Skype, or Teams meetings, but it is even more important in our context because we have participants who attend the hearing both physically and remotely. Should any party or participant wish to take the floor to raise a specific issue or respond to anything that has been said, please stand up if you are in the courtroom or raise up your hand if you are attending the hearing via video conference. Finally, should anyone attending the status conference via video conference experience any technical difficulty, please inform the court officer or myself immediately by waving your hand. If the connection has any problem for any of the remote participants, we will do our best to reconnect immediately. If the issue cannot be fixed immediately, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Let me now move to the recent procedural history of the case. On 11 November 2020, I scheduled this status conference, and I asked the parties to provide written submissions on the items listed in the annex to my scheduling order, the redaction regime to be adopted, and all the topics deemed necessary. The SPO submitted its observations last Friday. The defense teams submitted their observations yesterday. I thank all the parties for their written submissions, despite the tight deadlines. The purpose of our hearing today is to review the status of the case and to organize exchanges between the parties to ensure expeditious preparation for trial. In particular, I wish to discuss the status of the specialist prosecutor's investigations, the estimated amount of documentary and testimonial evidence the parties will bring to trial, issues related to the disclosure of the supporting material to the indictment, additional material intended for use at trial, exculpatory evidence, and protected material. And I also wish to discuss about the procedure for disclosure, the redaction regime to be adopted for the present proceedings, and finally, any other issue the parties may wish to raise. I will invite the parties to present their views in a concise fashion about each item. There is no need for each party to repeat their written submissions in detail. I would also like to inform the parties that the redacted version of my confirmation decision should be made available to the defense today or before the end of the week at the latest. In this context, I inform the defense that in my confirmation decision, I set a one-week deadline from the initial appearances for the SPO to submit any request for protective measures in the supporting material, so any current redactions will be conditional upon my decision on protective measures. Now I invite the parties to follow the agenda set out for the status conference, and we will start with the general questions. Before I give the floor to the parties on the general questions, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form, organized and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance of the case and not the greatest volume of evidence. In view of the publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I would like to first hear from the prosecution on the topics in this agenda, and I will give the floor to Mr. or Madam Prosecutor on this topic of general questions. Please.
Thank you, Your Honor. First, on the topic of investigations, certain investigative steps are continuing, and a number of those steps could only be advanced once the case became public. The most obvious example of that is the searches which were conducted in connection with the arrest of each of the accused. A significant volume of potentially relevant material was seized during those searches, and it's possible that additional investigative steps will be required as a result. The core issue here, though, is not any further investigations which the SPO is entitled to conduct. It is ensuring that disclosure is completed in a manner which is not prejudicial to the defence. That is a matter over which the Chamber will have oversight. The SPO has set out a timeline for meeting those obligations, and should that timeline change, the Chamber and the parties will be notified accordingly. With regard to the ability of the defence teams to commence their investigations, within the next 3 weeks, a very substantial volume of material will be made available, including the voluminous indictment supporting material and over 1,000 potentially exculpatory items. Each of these disclosures will be discussed in more detail later during today's agenda. In addition, the indictment itself contains very detailed allegations regarding the charges. At this point, and necessitated by the degree of detail with which the charges are specified in the indictment, certain redactions remain in place. I can confirm that it is our intention, following the Chamber's ruling on our forthcoming request for protective measures, to review the indictment with a view to providing a lesser redacted version consistent with any protective measures which the Chamber may grant. In summary, the defence has ample information with which to immediately start investigations. We have outlined an expeditious disclosure timeline for providing the remainder of the information. However, the reality is that from the information already available, the defence knows the case. The case is not a surprise. The lines of defence, some of which have already been outlined in Mr. Vasselli's submissions, are apparent, and none of the further disclosure supporting the prosecution case as outlined in the indictment will be a surprise. In the SPO's view, there is no reason why this case could not start in the summer of 2021. Thank you.
Thank you very much, Madam Prosecutor. Now I turn to the defense team, starting with Mr. Hooper. You have the floor.
In respect of the particular matter that we're dealing with just there, and with the last remark, that there'll be no surprise, well, not all of us have been on board in respect of this case anywhere near as long as the prosecution, and we're going to need proper and adequate time. The prosecution have conducted extensive investigations, as I understand it, at least over 5 years, but also resourcing material that was available as a result of other investigations going back perhaps 10, perhaps 20 years. We're going to need adequate time. Also, the prosecution was able to discharge its functions largely pre-COVID. We're in a COVID world. And in our submissions, as you can see, we've said that, I think fairly, because many of us have experience of these courts and these kinds of cases, that a minimum of 18 months is necessary before we would be, I think, even contemplating being trial ready. I find the suggestion that this case should go to trial in June absolutely absurd. We're not going to be put on a conveyor belt, a sort of judicial factory. That this is a complicated case. And I cannot see this case taking place any time before the summer, June, not of next year, but the year after that. And again, I emphasize that those estimates were given in discussion with colleagues against really an ideal world without COVID, which are going to obviously handicap matters. Secondly, in respect of the indictment, when you have an indictment that's redacted so that part of it reads on the blank day of blank, one really wonders if anyone has really truly put their mind to the inadequacy of the redactions in this case. In respect of disclosure generally, I'd ask whether the prosecution has a dedicated officer dedicated to reviewing the material they've got to see whether it does qualify as exculpatory or in other ways material that should be open to the defence. Our experience of other cases, both at the ICTYR or the ICC, is that there often isn't a dedicated officer, and that these particular tasks, and they're onerous and very deeply responsible tasks, are not in fact discharged by a dedicated officer. And the result is that there's a great defect in terms of the adequacy of disclosure. Those are all the matters I wish to raise in respect of those issues. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
May I take this as the opportunity to respond to the general questions section of the annex to the pre-trial judge's agenda for today's hearing. Firstly, as regards timing and scope of the obligations of the prosecution during the pre-trial stage and the defence investigation. Clearly, the touchstone test is the adequacy of the time and facilities afforded to the accused for the preparation of their defence. There is no fixed time limit, but a sensible and proportionate approach needs to be taken, using as the fundamental guideline the basic right articulated in Article 6 of the European Convention on Human Rights, that there must be an equality of arms between the prosecution and the defence, a reasonable level of proportionality in that regard, and that the defence must be given adequate time and facilities to examine and to prepare a defence after they have received sufficient particulars of the allegations to be able to conduct an effective investigation. I would have thought that those basic propositions are entirely uncontroversial, and it therefore came as something of a surprise and a disappointment to see the prosecution suggesting in its original written pleadings that the trial could begin soon after the first set of disclosure was complete. And more of a surprise and disappointment to hear junior counsel for the prosecution try to justify that just now on the basis that the accused must somehow know the allegations that are against them. That is an extraordinary position for the prosecution to be taking at the outset of a case of this magnitude and gravity, and we find it gravely disappointing that they should do so. It perhaps is an indication of the genuineness of the commitment to ensure that the proceedings are fairly conducted from the prosecution's point of view, and puts us all on notice of the need for great scrutiny of the positions that they adopt. That said, it is absolutely clear, based on experience of trials at the ICTY dealing with Kosovo, dealing particularly with allegations of joint criminal enterprise against members of the Kosovo Liberation Army, that the scope and nature of the investigations that are required by the defence will be extensive. They will be extensive because the prosecution's indictment and I think we all can readily recognize this, is built of a patchwork of multiple allegations over the entirety of the territory of Kosovo against large numbers of individual people alleged to be or claiming to be members of the Kosovo Liberation Army, which are stitched together in a suggested joint criminal enterprise. And therefore, it inevitably follows that each and every one of those allegations will need to be independently investigated and the crime base thoroughly examined. Previous experience of trials at the ICTY regrettably shows that false evidence was presented in numerous instances by the prosecution, not necessarily, of course, with any knowledge of its falsity, but nonetheless, a very careful forensic examination proved that certain parts of the evidence that have been adduced required the most careful and detailed scrutiny of the crime-based allegations themselves. So to hear prosecution counsel stand up and say the defense know the case against them, even though it is very substantially redacted and don't really need an investigation, is a shocking submission. The reality of the situation is that once we know the case against us, which will not be until the maximum de-redaction process has been completed, then it will require 18 months minimum of investigation. That time estimate is not plucked from the air. The previous trials at the ICTY involving Kosovo Liberation Army leadership, which had a very similar pattern but were far less extensive in scope, involved longer periods of pre-trial investigation, at least as regards the first indictments. And it's inevitable that the same thing will happen again. We, for example, propose an investigation supervised by an extremely experienced international investigator who will go through methodically the allegations on the indictment one by one and investigate them one by one in the process, in the way in which that in any defense counsel in these circumstances would require. That's an important point, because Mr. Hooper has already pointed out the prosecution have had 5 years to investigate these allegations and largely unlimited resources, certainly gravely disproportionate resources. It is the job of the pre-trial judge and the trial judges to hold the scales evenly and to ensure that the defense are not massively disadvantaged by that disproportionality. But to begin these proceedings by suggesting that there should be no need for an extensive defense investigation is, we would say, entirely wrong-headed. So realistically, we would support Mr. Hooper's suggestion that the trial cannot begin until the middle of 2022 at the earliest. I think, frankly, it's unlikely to begin then, realistically, because these things have a habit of not proceeding quite as planned. But assuming that the schedule is kept to, that the prosecution does meet its obligations, that it doesn't drag its feet on full disclosure of the particulars necessary to enable an effective investigation, then a period of 18 months following the May disclosure date might be a realistic target. As for the length of the trial, given that we have 200 proposed witnesses, 4 accused, and numerous, more than 100 instances across the entire territory of Kosovo and parts of Albania over a 2-year period, realistically, we're talking about a trial that will take between 18 months and 2 years. So that is the overall length of the process, and we need to be realistic and square up to it at this stage, rather than find ourselves having to drag the prosecution into a position of basic fundamental procedural fairness. It's disappointing, as I say. May I turn to the other part of my submission on the general matters, and that is the answers of the defence to question 1E in the judge's questionnaire in relation to matters which are specific defences or are, quotes, other grounds excluding criminal responsibility. As we've made clear in our written submission, we reserve our position about specific defences such as alibi until we know in detail what the allegations are being made against us. Plainly, we're not in a position to respond until we have the particulars, and by that I mean adequate details in a de-redacted form to enable us to know where it is alleged we were supposed to be and at what times. So on that, in relation to alibi issues and other areas of specific defence, we would reserve our position to make disclosure at the appropriate time in the appropriate way according to the rules. However, on behalf of Mr. Vasili, I would like at this stage to put on the public record some other grounds excluding criminal responsibility, which have already been adverted to by prosecution counsel when she said that we knew the case against us and therefore had no need for an investigation. Let me explain, first of all, what those points are, and secondly, why, far from showing no need for an investigation, they show exactly why an investigation will be so central and require so much detailed on-the-ground work. First point, to the extent that the SPO is able to prove the commission of particular crimes by individuals who were or who claimed to be members of the Kosovo Liberation Army during the indictment period, the accumulation of those individual crimes does not, the defence says, establish the existence of a joint criminal enterprise. No joint criminal enterprise existed, whether as alleged on the indictment or otherwise, and we say there is no other legal basis on which to hold Mr. Vasili liable for the criminal acts of others, which is what the prosecution in this case is trying to do. Second point, in the application of the international criminal law, context is everything. The Kosovo Liberation Army was a largely spontaneous and minimally organized popular uprising that operated in defense of the Albanian civilian population in the face of a carefully planned campaign of crimes against humanity, arguably amounting to an attempted genocide, the so-called crime of crimes. More than 10,000 Kosovo Albanian civilians were killed by the combined Serbian forces in numerous planned massacres as the country descended into chaos, lawlessness, and wholly asymmetrical civil war. They were buried in mass graves by the Serb forces, and many were later exhumed and their remains taken to Serbia, where they were hidden, some of them in lorry loads in the river Danube, in order to cover up the dreadful mass crimes that had occurred in Kosovo. The ICTY, the tribunal that was set up on a non-ethnic basis to try the crimes that were committed in that conflict, the ICTY has convicted 6 very senior Serbian army and military police personnel for their part in a coordinated plan to ethnically cleanse Kosovo of its Albanian civilian population through the commission of widespread crimes against humanity, with the express purpose of driving almost the entire ethnic Albanian population out of the country and across the borders into Macedonia, Montenegro, and Albania. To allege any sort of equivalence between that organized criminal conspiracy and the wrongful actions taken by a few members of the targeted community is a distortion of the facts and an inversion of the reality on the ground. When the SPO's evidence is viewed in its full context, the indictment will come to be seen as a travesty of the truth. The third point, the joint objective of the Kosovo Liberation Army was self-defense. In the context of a coordinated and sustained attack by the combined professional armed forces of the SFRY, Kosovo Albanian civilians who had taken up arms tried to organize themselves, village by village, into some kind of fighting force to defend their communities. In that context, there were sporadic and dislocated acts of armed resistance. And it is no doubt also true that in the political upheaval and military maelstrom that swept across the country, some individual crimes were committed by certain individuals on the Kosovo Liberation Army side. Those crimes, of course, Each and every one of them were inexcusable, but they were individual crimes on a minor scale in comparison with the industrial scale systematic slaughter that was inflicted on the ethnic Albanians by the SFRY. The only joint enterprise that existed within the Kosovo Liberation Army was a joint enterprise to defend the civilian population against the crimes being perpetrated by the SFRY. There was no shared intention to commit their objective through the commission of crimes against civilians. The opposite is true. The modest victories, indeed the very existence of the Kosovo Liberation Army, depended on the continuing consent and support of the people of Kosovo. That is not something that they could have hoped to achieve, or could in fact have achieved if they were pursuing a joint enterprise to commit war crimes and crimes against humanity against civilians. The so-called leaders that sit in the dock in these proceedings were, like other individuals around Kosovo, the commanders of the men and women who on any given day chose to follow them. These people were farmers by day and volunteer soldiers by night, if they chose to be. The one thing that they all had in common was a common purpose to act in self-defense of their community. The fourth point, the issue of common purpose alleged by the prosecution has already been extensively examined before in this context, during two lengthy trials at the ICTY against Kosovo Liberation Army leaders. The ICTY has previously recognized that in the particular context of the KLA, an accumulation of individual crimes during the relevant indictment period simply cannot be equated with a joint criminal enterprise. It's not a question of totting up individual crimes and finding someone to blame, nor did the commission of such crimes prove the existence of a joint criminal enterprise by inference. And the defense of Mr. Vasili will rely on those judicial findings as persuasive conclusions of both mixed fact and law. The fifth and last point I want to make is that the evidence will establish beyond the shadow of a doubt that the level of operational organization and lines of authority and communication within the Kosovo Liberation Army during the indictment period were so fragmented and rudimentary that it is impossible to assert or prove any legal basis to justify the SPO's extravagant reliance on the doctrine of command responsibility. This position was expressly recognized by the prosecution in the ICTY proceedings following an extensive investigation. No allegation of command responsibility was made because it is simply unsustainable and unrealistic on the facts of the Kosovo Liberation Army's organizational deficiencies to be able to mount a command responsibility prosecution. So those are the matters which we say exclude criminal liability and which at the end of these extremely lengthy proceedings will inevitably result in an acquittal of all four accused on joint criminal enterprise. And those are my submissions.
Thank you, Mr. Emerson. Now I turn to Mr. Young, please.
Your Honour, may it please you. I completely endorse and support the submissions of Mr. Hooper and Mr. Emerson, and for that reason I'll be very brief. In short, the prosecution's submissions are breathtakingly disappointing and frankly absurd. They're badly thought through, and frankly, their submissions have no regard whatsoever to an accused's right to a fair trial. Their suggested timeline makes a mockery of fair trial rights for Mr. Salimi. The prosecution may have had 5 years, 10 years, God knows how many years they've had, at least 5 years to investigate this. But I arrived here in The Hague last week. Are these accused, who've only recently had their indictments confirmed, expect to have foreseen, as if they had a crystal ball, that they would have their indictments confirmed? It's ridiculous. So I submit respectfully that the timeline suggested is utterly unrealistic. If we're to have proper time and facilities to prepare, to investigate the prosecution case, to analyse the prosecution case, as well as to conduct extensive defence investigations, then we need a fair and reasonable timeline. That's all I say.
Thank you very much, Mr. Young. Ms. Alexandra.
Your Honours, we've heard what the prosecution has to say, that the defence is ready to commence, should be ready to commence its investigations now. We do not agree with that proposition. We say that the defence will require adequate time and facilities to commence its investigations, and I adopt the submissions of my learned friends, Mr. Hooper, Mr. Emerson, and Mr. Young, just before me. The earliest we say the investigations can commence would be, and most realistically, is after substantial progress does take place on the prosecution's part, insofar as disclosure of material is concerned. On the preparation of the case, we say we require adequate time and facilities, and in this regard, I would ask that adequate be measured by the current circumstances that the defense will have to be in preparing its trial, the COVID times, as well as the time the prosecution has had to bring these indictments before this court. I believe that is all I have to say on this, on the investigations, Your Honour.
Thank you, Ms. Alexandra. Now I turn to the prosecution. Do you have anything to say after hearing the defense teams?
Yes, thank you, Your Honour. Only briefly. I believe my submission was clear that we're not suggesting that no defence investigation is required. Indeed, careful defence investigation will be required. Our submission is that in terms of understanding the prosecution case, the defence are in a position to commence such investigations immediately. Indeed, the lengthy submissions just made on Mr. Vasselli's behalf belie the fact that they are not in a position to do so. The SPO has taken note of the points raised by Mr. Vasselli's counsel, and no doubt they will be, to the extent relevant, exhaustively discussed at trial in light of the concrete evidence presented. We look forward to doing so. Thank you.
Thank you, Ms. Lawson. Unless any of the counsel has anything to add on this topic, doesn't seem to be the case. We will move to the next item in the agenda, but before that, I just want to mention for the benefit of the public that no date, of course, will be set for the beginning of the trial today. But what I can note is that the earlier the disclosure process from the SPO is completed, the earlier the defense investigation can also not only start, but also be handled in a speedy fashion. So we see that everything is connected, and the faster we can proceed from the SPO side, the faster it will be also from the defense side. Now, let me move to the second item in our agenda, which is the supporting material to the indictment. I would like to remind the SPO that within 30 days from the initial appearance, all supportive material to the indictment and all statements of the accused shall be made available to the defense. This is why the status conference had to be scheduled today rather than at the end of November, as requested by some defense counsel. I invite the SPO to give their submission on the disclosure of this supporting material to the indictment, but before, I note Mr. Young's submission regarding seeming discrepancy between the number of witnesses relied upon by the SPO for the purpose of the confirmed indictment, 153, and the number of witness statements, 130, that the SPO will disclose according to Rule 102.1a. So I invite the SPO to clarify this discrepancy. And I also note that several counsel propose that the SPO disclose the supporting material to the indictment on a rolling basis rather than in a unique batch 30 days after the initial appearance. Considering the volume of evidence to be disclosed under Rule 102.1a, the significant number of witness statements to be disclosed, the SPO's indication that significant redactions are required, the defense ability to receive, digest, and analyze the evidence disclosed, and the appropriate time needed for me to decide on redaction proposals, would it be possible to establish staggered disclosure deadlines that will ensure disclosure of the evidence on a rolling basis? And in order to start before the 30 days deadline, as requested by several defense teams, would the SPO need a couple of days beyond the 30-day time limit to finalize its disclosure obligation as set out in Rule 102.1a? These are the specific questions I would like to hear the parties on, starting with the prosecution.
Thank you, Your Honour. The SPO's indictment supporting material consists of approximately 1,842 items. This includes the evidence of 153 witnesses, some of which is in the form of statements, and some of which is in the form of transcripts. And I believe that addresses the query on the discrepancy. Translation of the indictment supporting material into Albanian has been worked on continuously since the date of submission of the indictment and is ongoing. Nonetheless, we anticipate having complete translations available to also disclose within the 30-day time frame. In addition, as Your Honour mentioned, the SPO will be seeking protective measures for a number of witnesses and victims identified in the supporting materials, and that filing will be submitted later this week in accordance with the order of the Chamber. On timing of the disclosure of this material, I don't believe there is any difference in principle between the SPO and the defence. As indicated in our submissions, we will disclose the Rule 102.1a materials as soon as we are in a position to do so. However, the necessary marker that I must place is that in this instance, as soon as possible, is unlikely to be significantly before the 30 days permitted to us. In fact, at this stage, what remains of that time period is approximately 3 weeks. We have been making preparations for this disclosure for many months, but as Your Honour noted, it is a large volume of material, and there are some very practical and logistical factors impacting the timing. This includes steps which could not have been taken in advance of confirmation of the indictment, including, as just mentioned, the necessity of protective measures. While not all material requires redaction, it does also take the full-time work of 3 people for 2 days simply to prepare a disclosure package of any reasonable size for release in legal workflow. Therefore, in this instance, diverting 2 or 4 or 6 days of work in order to provide rolling disclosure within the next 3 weeks could well jeopardize our ability to meet the 30-day time frame. So while we are committed to that time frame and to the principle of disclosing as soon as possible in this case may well be close to the 30 days which we are permitted. Thank you.
Thank you very much. Ms. Lawson, just on to follow up on what I mentioned before, would that be of any help if you were benefiting from a couple of days beyond the 30-day deadline in order to start the disclosure process of a first batch before that? Because that's what has been suggested, or at least requested by some defense teams, in order not to have everything disclosed in one batch.
Any extension of the 30-day time frame would certainly be of assistance. However, the reference made to a couple of days would not significantly assist in enabling rolling disclosure to commence more in advance than I have indicated. Thank you.
Thank you very much, Ms. Lawson. Now I turn to the defense teams, starting with Mr. Hooper, please.
I've got very little by way of response to those matters. What I would say is this, that disclosure in this sense is seen as triggering investigations, but that's not going to be the case. When you've got a great amount of material to deal with, then you have to address that material. Not only that, you have to assimilate it in order to choose your target investigations. So we mustn't get that idea that, once these disclosure obligations are fulfilled, that the defense is then, that it's a starting gun, as it were, for the investigations. It just doesn't, in practice, work like that. That's my only observation. Thank you.
Thank you very much, Mr. Hooper. Mr. Emerson.
Your Honor, I would like to make it clear that we recognise that the prosecution has a great deal of material to work through, and we recognise that the disclosure obligations are extensive, and that the work that they will be doing on translation and redaction is time-consuming. And frankly, for the sake of a few days in advance of the 30-day deadline, it does not seem to me, with great respect to those defence counsel who take a different position, that we are really talking about days, problems and delays measurable in days. The issue is, once the material has been disclosed, is it in a workable form? And my main concern, and I think I've made this clear both in writing and orally, is that the defence should not be placed in the position of having to come back before the pre-trial chamber again and again and again, as has happened in some other proceedings in other courts, in order to seek de-redaction so that they can conduct effective investigations on the material. If the prosecution over-redacts in the first instance and then resists requests for de-redaction, so that we end up in a position where the defense and the judge are trying to pull teeth from a reluctant prosecutor, that will delay the process enormously. And so I, for my part, and this applies across the board as far as the procedural proposals of the prosecution are concerned, take the position that it is for the prosecution to discharge its disclosure obligations, and it's for the prosecution, therefore, to devise the process by which that should be done. I'm not going to make submissions on the proposal that they make. I will wait to see if they, first of all, keep to their own deadlines and conduct the disclosure exercise in a spirit of genuine cooperation aimed at securing the interests of justice. or whether the situation begins to become derailed as time goes on. And that can happen. Experience shows, sadly, almost in every case, that the realities do not meet the procedural expectations set out at the outset, and things don't usually run as smoothly as one hopes that they will. That doesn't mean to say there shouldn't be a careful plan at the outset. Our position is to sit back and wait and see how that plan begins to unfold, and to reserve the submissions that we might make about its practicability and its fairness for perhaps the next status conference or the one after that, when we see how it is operating. I note, though, that here we are at the first status conference with junior counsel for the prosecution saying any extension to the 30-day deadline would be welcomed. So I think one can see, even before we've begun, that there are likely to be slippages, and they're likely to be slippages from a prosecution point of view. The defence will do everything we can to ensure that the proceedings are as efficient as possible to make the pre-trial chamber's job as easy as it can be. Those are my submissions.
Thank you, Mr. Emerson. Now I turn to Mr. Young.
Your Honour, thank you. Very briefly, firstly, may I thank my learned friend for the prosecution for clarifying and making it clear that what the discrepancy was in the figures. That's understandable. I say no more, really. Obviously, we'd like the material as soon as possible. We appreciate that the prosecution have a massive responsibility given the size and scale of the case. I don't really make any further submissions on this point, but I would like to address you in a little detail on the procedure for disclosure later in the hearing. Thank you.
Thank you, Mr. Young. I think in your written submissions, Mr. Young, you were requesting the disclosure to start before the 30 days deadline, at least for part of it. Is it still an important point for you? Because that's why I was suggesting at the beginning that we make it in different batches so that you can have access to some part of the evidentiary material as early as possible, giving a couple of extra days to the SPO to finalize its obligations.
Your Honour, as Mr. Emerson said, in the scheme of things, a few days really matters very little given the size of these proceedings and the length of these proceedings. So we take no strong point there.
Point taken. Thank you, Mr. Young. Now I turn to Ms. Alejandra, please.
Your Honor, we too are seeking that disclosure begin as soon as possible and in batches so that we can at least receive what is available immediately.
Thank you, Ms. Alejandra. I will give back the floor to the prosecution, and I will add that if you had, for example, 2 more weeks for your disclosure obligation, would it help to start the disclosure process before or not? Ms. Lawson.
Your Honour, our position is that we currently envisage being able to meet the 30-day deadline. Our preference would be to do that. And I don't really have anything further to add to that. Thank you.
Thank you very much, Ms. Lawson. Unless any of the council has anything to add, I don't see anybody waving. So we'll move to the next item in the agenda, which is the additional material intended for use at trial, which is the Rule 102.1b material. I take note that the SPO intends to disclose further material under Rule 102.1b. The SPO expects to be ready to disclose this additional material to the defense by 31st May 2021, or 30 days prior to the opening of the SPO's case. I invite the SPO to explore the possibility of disclosing material falling under this category on a rolling basis, for example, every few months, in order to allow the defense teams to familiarize themselves progressively with the evidence rather than in one very large batch. Ms. Lawson, you have the floor on this item.
In terms of the material the SPO intends to rely upon at trial, in addition to again relying upon the majority of the 153 witnesses whose evidence was used for the purposes of confirmation of the indictment, the SPO anticipates relying upon the evidence of approximately 50 additional witnesses. In terms of documentary evidence, the SPO anticipates presenting approximately 1,500 exhibits at trial. This is a preliminary estimate, which may vary as a result of the ongoing investigative steps. On timing, the SPO has undertaken to provide this material in batches as and when it is available to disclose, and with a view to completing the disclosure by 31 May 2021, subject only to any applicable protective measures. What cannot be done at this point is to identify which particular subsets of the material will be disclosed at which particular time. It might seem at first glance, for example, that unredacted material or material not requiring redaction could all be disclosed first. However, in order to identify which materials do or do not require redaction, it would be necessary to first have completed redaction review of all of the materials. Therefore, the material will simply be disclosed in batches as and when they are available, regardless of redaction or other status. It will be a rolling disclosure. Finally, with regard to the 31 May 2021 timeline indicated by the SPO, this date was put forward with a view towards moving the case as expeditiously as possible towards trial. Should it be the case, as suggested by certain of the defence teams, that they in fact envisage 18 months to prepare for trial, the SPO will be seeking an amendment of that date. The framework does not envisage, and it would be unreasonable to require, exhaustive witness and exhibit disclosure more than a year ahead of any scheduled trial date. Thank you.
Thank you very much, Ms. Lawson. Now I turn to the defense teams. Mr. Hooper, please.
Well, if they say they can achieve disclosure, full disclosure by May, then why shouldn't they do that? That's all I have to say.
Thank you, Mr. Hooper. Mr. Emerson, please.
Again, I find myself surprised and disappointed that the prosecution should seek to take advantage of the fact that the defense needs to conduct a detailed investigation to justify delaying the disclosure that it is required to provide. On the contrary, the defense time estimate for its investigation takes as its starting point the conclusion of the prosecution's disclosure obligation. It is, I'm going to choose my words extremely carefully, it is not appropriate prosecutorial conduct to suggest that the disclosure of material in advance is an undesirable objective, so that they will, which is what you've just been told, consciously delay their disclosure obligations so that they are discharged closer to the trial date and therefore reduce the available opportunities for the defense to investigate. That is what's just been submitted to you. It's an extraordinary proposition. that a prosecutor who says, I give you the 31st of May next year as my deadline, then comes back and says, but if the trial isn't going to take place immediately after that, so as to railroad the defense into a trial without preparation, we want to delay the disclosure. I mean, these are very poor signs of the approach that the prosecution is intending to take to its professional obligations. And I know, Your Honour, that the pre-trial chamber and indeed the trial chamber in due course will ensure that the prosecution is kept to its fundamental duty, which is to ensure a fair trial. It seems that those who have formulated the position that have just been articulated to you in the course of this process are slanting their tactics for the specific purpose of preventing a fair trial. I find it extraordinary that these submissions should be being made by counsel in the course of this hearing in this way. Of course, the prosecution must keep to its deadline of May next year, and then we have a reasonable period, adequate time and facilities, in the words of Article 6 of the European Convention, once we have been informed of the particulars of the case against us, to investigate and defend ourselves. Why is the prosecution so keen to deprive the defence of a fair opportunity to test this allegation? What is it that the prosecution thinks it gains in terms of an advantage as far as the interests of justice are concerned by having the case brought forward in a way that enables the disclosure to be given at the last possible minute? What's the justification for that position? I'd be interested to hear the reply.
Thank you very much, Mr. Emerson. Mr. Young, please.
Your Honour, I'll be very brief. If I may use a French expression, I would suggest that in these international cases, for good case management reasons, there sometimes needs to be a guillotine. There should be a guillotine where disclosure stops. With great respect, one of the lessons that we've learned from some of the very long international trials in The Hague is that the prosecution have too often been allowed to continue the disclosure exercise for lengthy periods. So they serve batches and batches over a long period of time, and it does not allow the defence a period of time to breathe, to take stock, to see the overview of the prosecution case. And so what I would advocate, Your Honour, respectfully to Your Honour, is that Your Honour consider a guillotine where disclosure must stop. Because if there is no firm case management, in my experience, prosecutors will continue to disclose and that will make things more difficult, particularly for the accused who are on trial.
Thank you, Mr. Young. Ms. Allegendra, please.
Your Honor, we ask that the prosecution be stopped as at 31st May to provide the disclosure so that the defense has adequate time thereafter to prepare for trial.
Thank you, Mr. Allegendra. I give back the floor to the prosecution to respond. And I would add, regarding what you were saying about the disclosure in batch, if a monthly deadline would assist when you disclose the different batches. Ms. Lawson, you have the floor.
Thank you, Your Honour. To be clear, there is no suggestion that the SPO would deliberately delay or otherwise withhold disclosure. As I stated, it will be rolling disclosure as and when the material is available. The only point that I was making was in fact in reference to the guillotine concept raised by Mr. Young. No guillotine should be applied so far in advance of trial. Nonetheless, the prosecution intends to comply with the timeline that it itself has outlined and complete disclosure by the 31st of May 2021. As for monthly disclosure deadlines, we do not consider that to be necessary. As I indicated, it will be a rolling disclosure as and when available. Sometimes we would hope more frequently than that, sometimes perhaps monthly. We think it would be more appropriate for the specific timeline of those disclosure packages to be left to the discretion of the prosecution, which will be decided not based on our discretion or on any withholding of information, but as and when the material is available. Thank you.
Judge, may I?
Thank you, Ms. Lawson. Mr. Emerson, you requested the floor.
Yes, for the purposes of the record, what Ms. Larson has just said is not an accurate representation of the submission that she made earlier on. It's not true to say that she was referring to the guillotine. What she said in her earlier submission was that if the defence envisaged a much later trial, prosecution would then seek to put back the 31st of May date because it would be giving the defence advance notice to too great an extent of the allegations. She then changed that submission in her response and claimed not to have made it, saying instead that the prosecution would stick to the 31st of May position. I say that because it seems to me, with great respect, relatively clear that the prosecution is boxing and coxing on the hoof, but that fundamentally the aim is to make these proceedings as difficult as possible for the defence. And the question I ask, and which has still not been answered in the reply, is why the prosecution is so keen to avoid a fair trial process.
Thank you, Mr. Emerson. Does any of the counsel want to add anything? No. Ms. Lawson, do you want to add anything on this?
No, thank you, Your Honour. I believe my submission with its clarification was in fact clear.
Thank you, Ms. Lawson. Now let us move to Rule 103 material, which refers to exculpatory evidence. I remind the specialist prosecutor that it must disclose immediately to the defense any exculpatory evidence as soon as it is in the custody, control, or actual knowledge of the specialist prosecutor, which may reasonably suggest the accused innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence. Disclosure of exculpatory evidence is a continuous obligation, subject only to protective measures where necessary. I take note that the SPO intends to disclose some Rule 103 material at the time it discloses the supporting material to the indictment. I'd like to give the floor to the SPO to provide further details regarding this category of disclosure. Ms. Lawson.
Yes, Your Honour. The SPO will be disclosing over 1,000 potentially exculpatory items, not later than disclosure of the indictment supporting material. And consistent with our obligations, will continue to immediately disclose any potentially exculpatory information on a rolling basis. There were two other points in relation to exculpatory disclosure which I'd like to address. With respect to the SPO's request to be exempted from having to formally disclose information which is known and accessible to all, I would like to emphasize that what we are proposing here is not a radical or wide-ranging proposition, and nor is it likely to result in litigious rabbit holes. Certainly, it does not extend to non-public information of which the SPO is aware, and such material will be disclosed pursuant to Rule 103. The proposition is in fact one which is already well understood and circumscribed. It comports with common sense and has been acknowledged by the appeals chambers of the ICTY, ICTR, SCSL, and ICC, amongst other courts. It's a well-recognized and understood concept which would be appropriate to also apply in this context. Finally, regarding the request by Mr. Salimi's defence for each piece of exculpatory information to be specifically referenced to indictment paragraphs or to other evidentiary material, such a request far exceeds the requirements of the disclosure framework and is not something that the SPO is in a position to do. It's important to note in this context that a number of other tribunals do not even require the prosecution to identify material being disclosed as exculpatory. The framework here does require that, and the SPO will be complying with it, thereby giving the defence notice of the potential importance of the material, and this should be more than sufficient to facilitate the review. Thank you.
Thank you, Ms. Lawson. Mr. Hooper, please.
Yes, I rather jumped the gun on this issue, perhaps at the outset of my submission, so I won't repeat it all again. But I've noted difficulties that have arisen in this process of the prosecution, as it were, self-identifying the exculpatory material. And though it would also still remain in-house in terms of someone applying the criterion to the material they hold, I'd request the prosecution to consider dedicating or having a dedicated officer to review their material so that the exercise is done by an identifiable person with an obligation to discharge what is, after all, quite a heavy responsibility. Thank you.
Thank you, Mr. Hooper. Mr. Emerson.
I take a slightly different approach. The proposal put forward by the prosecution seems to us eminently sensible as regards material that is accessible in the public domain to all parties, with the proviso that by casting that burden on the defence, it is, that's to say, the investigative burden of material of that nature. Obviously, that needs to be taken into account in making a due allowance for the length and depth of the defence investigations. It will increase the burden on the defence to identify material from the public domain, which the prosecution already has in its possession. But I nonetheless entirely endorse the proposition that it is a reflection of the practice of other tribunals and of common sense, that if material is generally available, it ought not necessarily to be the prosecution's obligation to identify it. As far as the methodology of the prosecution is concerned, the defence of Mr. Vasili takes the position that it is not for the defence to tell the prosecution how to do its job in relation to disclosure. We will see how it is done and make our comments at that stage. I don't endorse any particular proposal for the appointment of a disclosure officer or of any other aspect of the prosecution's discharge of its function. That is for them. And the results will be what form the basis of my submissions to the court in due course.
Thank you, Mr. Emerson. Mr. Young.
Your Honour, may I please, 2 short points. Firstly, I'm sure you will understand that in relation to exculpatory material, the defence would never suggest there would be a guillotine at any stage. Clearly, in the case of exculpatory material, which is so important to the rights of an accused, that should be disclosed at the earliest moment and any time, such as its importance. The second point, Your Honour, in relation to our submission, which is found in paragraph 27 of our filing, we stand by that submission. The prosecution have now argued that the responsibility we suggest, and let me just repeat what we drafted in the submissions, we advocated that the prosecution should be required, when disclosing exculpatory material to the defence, to explain how each piece of material is considered exculpatory by reference to the paragraph of the indictment, witness or other documentary evidence to which it relates. Your Honour, with respect, we do not accept what's just been submitted by the prosecution, that it far exceeds the disclosure framework. We would submit that this is an opportunity for good case management, whereby the court has an opportunity to direct that this important material, this is what the most important category of disclosure, exculpatory material, that this important material is made meaningful to the parties rather than dumped on the parties. I'm not suggesting that we need a treatise or a lengthy explanation of the importance, but a succinct, short statement which makes it clear how the concession is being made that the material is exculpatory. This is really important for the rights of Mr. Salimi. Thank you.
Thank you, Mr. Young. Ms. Alexandra.
Your Honor, we do not agree that the prosecution should not be required to disclose potentially exculpatory open source items. We refer to the wording of Rule 103 on this, and it is unequivocal. We say that the prosecution shall immediately disclose to the defense any information here being rather including open source material. So on that regard, we ask that they not be relieved of that obligation. And we also feel that it is not necessary for the prosecution to make an assessment as to whether or not exculpatory material is accessible with due diligence. That would be reversing the burden on us. I also wish to endorse the position taken by Mr. Young earlier on this.
Thank you, Ms. Alexandra. Ms. Lawson, do you want to reply to the defense submissions?
Not other than to say that we obviously are aware of and accept our obligation to disclose potentially exculpatory material as being an ongoing obligation. Thank you.
Thank you, Ms. Lawson. Unless any of the council has anything to add in this topic, let me now move back in the agenda to the Rule 102.3 material, which is the evidence material to defense preparation obtained from or belonging to the accused. I would like to remind the SPO that disclosure or inspection of evidence, such as statements, documents, photographs, or tangible objects material to the defense, must be disclosed without delay. What is considered material to the preparation of the defense must be understood broadly. I also remind the parties that disputes as to the materiality of the information as claimed by the defense must be submitted immediately to the pretrial judge for resolution. I also take note that the SPO in its submissions anticipates providing the defense with detailed notice of evidence material to it by 30 April 2021. I would now like to hear the prosecution submissions on this category of evidence. Ms. Lawson, you have the floor.
As Your Honour just noted, the SPO anticipates providing detailed notice of Rule 102.3 material by 30 April 2021. Consistent with the applicable jurisprudence, what may be material to the preparation of the defence is to be broadly interpreted, and therefore we do anticipate that there may be a quite lengthy list of material falling under this category. Identification of that list cannot be completed until witness and exhibit lists, as well as exculpatory disclosure, are well advanced. In accordance with the applicable framework and based on the detailed notice which the SPO will provide, it will then be for the defence teams to identify and request material which they believe to be material to their preparation. The potential relevance of material disclosed pursuant to Rule 102.3 is therefore relevance which the individual defence teams themselves will have identified. Regarding the submission from Mr. Salimi's defence that material obtained from the accused should be disclosed immediately, the vast majority of such material was in fact only very recently obtained as a result of the searches and seizures conducted in connection with the arrest of each of the accused. There is a considerable volume of such material, some of which is in electronic form, other in paper format. The SPO is processing this material as expeditiously as possible, and within the 4-month time frame authorized by the Chamber, will be returning or destroying any items which are not relevant, and thereafter processing and disclosing items of relevance in keeping with the timeline indicated in our submissions. Finally, the defence for Mr. Salimi requested a particular procedure and timeline for processing of defence disclosure requests under Rule 102.3, to which I would like to respond. We do appreciate that judicial intervention, or indeed regulation, may be appropriate in certain instances, in particular where there are difficulties being encountered and where the parties are unable to agree on an inter partes basis. That is not the current situation. The parties should be afforded a degree of discretion in managing their disclosure obligations in a reasonable and efficient way. Indeed, at this stage, a process of the type proposed could only be counterproductive. It is necessary for the benefit of each defence team that disclosure of indictment supporting material and of exculpatory material be prioritised. The process for everyone could be very significantly waylaid were one or more defence teams to start making large, premature, and individualised requests in advance of having received and reviewed that core material. Thank you.
Thank you, Ms. Lawson. Before I give the floor to the defense team, I would just like to ask the interpreters if they agree that we continue for probably 10 or 15 minutes before a short break in order to finish the discussion on the different category of evidence material. If you can let me know if it's...
That's fine, Your Honor. We can continue.
Continue for a couple more minutes so we can break before we have a discussion on the procedure for disclosure, which will be a good time to have a short break. Sorry, Mr. Hooper, you have the floor.
Yes, I've no comment to make other than this. Can we have formal service of the transcript of interview that Mr. Thaci participated in earlier in the year? Thank you.
Thank you, Mr. Hooper. The prosecution will respond afterwards. I give the floor to Mr. Emerson.
Your Honor, I have nothing material to add. I think I've made our position clear as far as the disclosure regime is concerned, namely that we accept that it is for the prosecution in the first instance to devise the method of discharging its obligations, and we recognise the force of the submission that the prosecutor must be given a reasonable degree of latitude and discretion in the manner in which it does that. As I said before, we will reserve our position to see how it works in practice and whether or not disclosure is given with the spirit of fairness that is necessary.
Thank you, Mr. Emerson. Mr. Young.
Your Honour, thank you. I have nothing to add, save that we do stand by our submissions in paragraph 24 of our filings. And we submit this is a sensible proposal, and we ask Your Honour to consider it.
Thank you, Mr. Young. Ms. Alejandra.
Your Honor, we reserve our position on this at this stage, and we see how it works in practice once we receive it.
Thank you, Ms. Alejandra. Ms. Lawson.
I can confirm that copies of Mr. Thaci's transcripts will be included in the material to be disclosed within the 30-day time frame. Thank you.
Thank you, Ms. Lawson. Let us move now to the protected material, which is the Rule 107 material. In its submission, the SPO mentions that it is actively seeking remaining Rule 107 clearances. I would like the SPO to further explain the amount and category of material that still require clearance. Ms. Lawson.
Yes, thank you, Your Honour. As we outlined, we are actively working on obtaining remaining clearances. The material in question is material which we have identified as being potentially relevant, therefore falling under Rule 102.3. The SPO has been working with the institutions in question for over 18 months in respect of such clearances, and we have kept them apprised of applicable and anticipated disclosure deadlines. We do not currently anticipate that obtaining such clearances will jeopardize the timeline that we have indicated, and therefore we envisage that requests to the Chamber, if any, would be made in sufficient time to meet that timeline. Should the assessment change, we will promptly inform the Chamber. Thank you.
Thank you, Ms. Lawson. Mr. Hooper.
Yes, I have no comments to make. Thank you.
Thank you. Mr. Emerson.
Nothing to add.
Mr. Young.
No, thank you.
And Ms. Alejandra.
No comments, Your Honour.
Thank you. It went faster than I thought, so it's now 12:27. I think it would be probably better for the interpreters to have a short break. We're gonna have a break for, let's say, 13 minutes, so we will resume the hearing at 12:40. The hearing is adjourned.
All rise. All rise.
Please be seated.
Let us now move to the procedure for disclosure. In its submission, the SPO indicates that inter partes discussions are still ongoing regarding the Rule 109C chart, but that it prefers an approach consistent with the one that has been taken in the Mustafa case. I also note that several counsel requested disclosure charts for each package of disclosure rather than only after the pretrial brief. I first invite the SPO to give further detail on this topic. Ms. Lawson.
Thank you, Your Honour. Before we start, I would just like to note for the record that Specialist Prosecutor Jack Smith has left the courtroom. With regard to categorisation of information pursuant to Rule 109C, in accordance with Your Honour's direction, the SPO promptly initiated inter partes discussions on this topic on the 12th of November, circulating a proposal to each of the defence teams. The proposal was, as you noted, largely based on the approach previously adopted in the Mustafa case before this court. On Monday morning, and in light of responses which had been received from certain of the defence teams, we circulated a further revised proposal. We remain available to discuss the topic further on an inter partes basis with a view to attempting to reach a common position. However, there are just 3 points that I think it is worth making now. The first is one that I have made previously before this court, albeit in the context of different proceedings, and that is that the requirement upon all parties under Rule 109C is for categorization to be so far as practicable. That is, what can be done within the resources and means which are available. The categorization should not and must not become a burden so onerous that the expeditiousness of proceedings are jeopardized. Second, and relatedly, the format in which any categorization is ultimately required and the timing by which that can be done are deeply interrelated. The proposed chart format which the SPO presented was conditional upon it being provided only after production of the pre-trial brief. Should that timing be altered, the content and format of any chart may also need to be altered. Finally, no navigational aid of this nature is going to prevent the need for the materials in question to be read and analysed in full by all parties. Consequently, imposing a categorization requirement which would delay provision of the materials themselves, which, for example, requiring production of a detailed chart together with each disclosure package would do, is, in our view, simply counterproductive. Nonetheless, as I indicated, we remain available to continue these discussions on an inter partes basis. Separately, in their written submissions, Mr. Thaci's defence raised an objection to material disclosed by the parties being made available to the Chamber, indicating that it would be prejudicial to their client for the trial panel to be able to see such material. The SPO considers that the question of access to such material is a discretionary matter for the Chamber. We can certainly see that it is beneficial for the pretrial judge and ultimately the trial panel to receive such material, in particular in order to facilitate meaningful oversight of the disclosure process. What the defence appears to be suggesting is that a panel of professional judges will not be able to separate out and distinguish the material which is submitted into evidence before it from other information, and that is a contention which we do not accept. Turning to the proposed redaction regime. As Your Honour has previously recognised, such a regime is well established and well proven.
Ms. Lawson, sorry to interrupt. Maybe we'll have a separate discussion on the redaction regime, and we'll first start with the procedure, because it will be already quite important. So if you don't mind, I'll give you back the floor on the disclosure, the redaction regime afterwards.
Certainly, Your Honour. Thank you.
Mr. Hooper, you have the floor on the procedure for disclosure.
Thank you, Your Honour. Well, you've seen our submissions. May I defer to Ms. Menegon, who's present in court, who's had far more experience, if I may say so, at having to deal with issues of disclosure and the difficulties that that arises, and particularly with the metadata and the like. Can I invite Your Honour to invite Ms. Menegon to add any further comments that she might feel appropriate?
Absolutely. Ms. Menegon, you have the floor.
I thank you, Your Honours. What I wanted to stress is for the category of information provided by the prosecution with each batch of disclosure, what we would like to is that each evidence be connected in the metadata in the legal workflow to the underlying crimes, contextual elements, conduct of the accused, etc. The idea is that for us, we can then issue a list of evidence by topic, by crimes, by contextual elements. We don't necessarily need, I think, the prosecutor to issue a specific chart at each disclosure package, but we need to have at least the metadata, the links done already by the prosecution with this category of information envisaged by the rules in the metadata, in the legal workflow. And the IT system should allow us to export this data in table format for us to be able to organize our work. And then, of course, after the filing of the pre-trial brief by each party, then we will need a consolidated chart by each party, which details this category of information, and eventually with more details, because we have not received anything yet. So for us, it's a bit difficult also to know exactly how everything has to be divided by the prosecutor in his presentation of evidence. I thank you.
Thank you, Ms. Minigon. Mr. Emerson.
Your Honour, as regards the relevance question and the preparation of a chart, we would endorse the approach urged upon you by the prosecution, which is that this is no more than a preliminary navigational tool, and that the defence will inevitably need to consider all of the material in very great detail for the purposes of its investigation. And the touchstone here, in terms of obligations on the prosecution and the defence, must be one of proportionality. So I would not seek to go behind the prosecution's emphasis on the words "so far as practicable" in relation to the categorisation exercise. It is useful as a starting point, but it ought not to result in a substantive delay in the disclosure process. As far as the separate submission made on behalf of Mr. Thaci is concerned, we do not endorse that submission in relation to material being available to the trial chamber. We all have different experiences. Having sat myself as a judge in the ICTY, I am entirely satisfied that the tribunal is perfectly capable of distinguishing that which is relevant and admissible from that which is irrelevant and inadmissible and prejudicial. So I certainly would not endorse that proposition. Those are my submissions.
Thank you, Mr. Emerson. Mr. Young.
Your Honour, thank you. In direct response to what's been said to Your Honour by the prosecution, Your Honour, my learned friend for the prosecution has said that these charts, as we suggested, would be an onerous burden upon them. And we do accept that if Your Honour were to accept our proposal, then it would require the prosecution to exercise some more time than usual. But we would submit that in the longer term, more time would be saved by having regular rolling charts. And so I'm going to make some specific submissions on this. We would like to, and Your Honour will know for the record, in our written submissions, page 10, paragraphs 33 to 36, we effectively welcomed and commended Your Honour's, what we would say was an innovative initiative of ordering detailed disclosure charts. As Your Honour knows, Your Honour directed before my arrival in the case that the parties consider a disclosure model chart which satisfies the requirement of Rule 109C. And obviously Your Honour asked for that to be discussed today. The SPO has put forward a proposal, and may I make it clear, we're completely prepared to engage constructively with the prosecution on attempting inter partes to shape and create a suitable disclosure model for this case. And what we strongly reject, however, is the prosecution proposal in their 4th of November filing on the Rule 109C categorization chart, namely in terms of the timing, which is just not acceptable. They propose it be submitted only 1 week before the submission of the SPO's pre-trial brief. That is simply not acceptable to us and far too late. And so we do commend our proposal in paragraph 34 of our filing for the prosecution to provide these detailed charts on a rolling basis But as I say, given the size and scale of these proceedings, in the longer term, we would say that more time will in fact be saved if the parties have these categorisation charts. And with respect, Your Honour, it's not simply the defence that would benefit from this innovative model that Your Honour is suggesting. With respect to Your Honour, the prosecutors themselves even may well find that these charts, if they were required to undertake them, would concentrate the mind on relevance, on context. It would focus minds so that the parties in these proceedings can understand the prosecution's journey in the evidence and journey in the proceedings, as opposed to having, effectively, a massive disclosure of evidence, effectively, at the last minute, whereby everything falls into a legal black hole in a computer system. So what we submit is this, that Rule 109 embodies good case management. As Your Honour knows well, there are no specific timelines from my recollection within the rule itself, but if reasonableness is the guiding test, which is implicit, then the aims of Rule 109 to make disclosure meaningful in effect are entirely consistent with our proposal with respect. And so we do submit that Your Honour should direct these charts to be produced on a regular, rolling basis. And as I say, we will cooperate with the prosecution, we will engage with them and attempt inter partes to create a model that's bespoke for this case. Thank you.
Thank you, Mr. Young. Ms. Alejandra.
Your Honor, we are agreeing on the use of the detailed disclosure chart as proposed and revised by the prosecution. We will also cooperate and participate in the ongoing discussions on the model of the chart with the prosecution, Your Honors. But we do also endorse the view of Mr. Young that some identification of the relevance of the material that's being disclosed is fundamental to our preparation. So we request for that. That is all.
Thank you, Ms. Alejandra. I give back the floor to the prosecution, and I will also ask Ms. Lawson, how long would this inter partes discussion last? Would you be in a position, according to your preliminary discussions, to have an agreement, or at least to be able to let me know where you are in the discussions within a couple of days or within a week? You have the floor.
Thank you, Your Honour. As you could tell from the submissions made, I believe there is room for us to make progress on this further in an inter partes manner. With regard timing, I would, well, it will obviously involve all of the parties. I would suggest that we could perhaps revert in a week's time, if that is agreeable to the council with whom I'll be interacting. Thank you.
Thank you, Ms. Lawson. Now I turn to the defense team. Would 1 week timeline for the discussions you would have with the prosecution on the chart be sufficient to you, or do you need less or more time? If it's less, that would be wonderful, of course. Mr. Hooper.
I would have thought a week. Sorry, can you hear me? Yeah.
Absolutely.
I'd have thought a week appropriate. I'm not entirely clear what Your Honour has in mind will happen at the end of the week, presumably that we seek an agreement between us. I don't think we need a further hearing, do we? Yeah.
No, we don't need a hearing, but it's mainly in order for me to be briefed before adopting the framework decision on disclosure.
Well, in that case, then I'd say a week, because we're scattered all over the place in different time zones and circumstances, and I think it would be far more convenient for the defence in those circumstances to hopefully have reached discussions with the prosecution in conclusion in a week's time. So Thursday next week.
Thank you, Mr. Hooper. Mr. Emerson.
I don't think I need any time at all. I can say here and now that I have nothing to add to that process. As I've indicated throughout, I consider the disclosure obligations to be obligations that rest on the prosecution. I will see the way in which they are discharged. I have nothing beyond what I've already said to say about categorization. And so in those circumstances, we don't require any further time to make have additional discussions with the prosecution. We'd be grateful to be kept informed.
Thank you, Mr. Emerson. Mr. Young.
We'll endeavour to do this within 1 week. Thank you.
Ms. Allegendra.
1 week is reasonable, Your Honor.
Thank you, Ms. Allegendra. Thank you very much for your work on this issue. Given the timeline we have for the 30-day deadline for the disclosure, I may have to issue actually 2 decisions on the redaction and probably delay the ruling on the disclosure chart because I don't want to delay the disclosure evidence within the 30 days deadline for that. But I thank you in advance for your work on this because I think there is definitely an agreement that could be reached at least on the structure of the chart. Now let me move to the last topic, which is the redaction regime. And sorry again, Ms. Lawson, to have interrupted you before. In adopting a redaction regime, it is necessary to ensure the efficiency of the disclosure process while striking a balance between the duty to protect the interest of the victims and witnesses and, of course, upholding the rights of the accused. In its submissions, the SPO requests to adopt the redaction regime that is applied in the Mustafa case. I invite the SPO to make further submissions on this topic.
Thank you, Your Honour. My submissions on this will in fact be very brief. As Your Honour has previously recognised, such a regime is well established and well proven as an efficient means of expediting and overseeing the disclosure process. The regime applies a system of prior judicial authorization for all redactions. This authorization is simply done by way of a category in respect of certain limited types of information, and we endorse the submissions that we made in writing. Thank you.
Thank you, Ms. Lawson. Mr. Hooper, please.
Yes, no, we have no objection to the regime that was spoken of in the Mustafa case. My only concern is this. I don't know whether the prosecution have effectively already been putting this regime into practice. But if they have, then it's had some very strange results because we've seen redactions where, for example, well, I'll come back to that perhaps at a later point. But there does seem to have been a great number of quite unnecessary redactions on the face of documents we've received. So I hope this isn't a practice that the prosecution will already consider that they're employing, because it would have an unfortunate effect if that's the case. But we have no objection to the Mustafa regime being the regime in this case.
Thank you, Mr. Hooper. Mr. Emerson.
What has come to be called the Mustafa regime is nothing more or less than the identification in advance of categories of material to which redactions could properly be applied. That is not a complicated exercise. What is a complicated exercise is applying those general categories to the data in individual statements. It's inevitable that any generalized system that is category-based will result in over-redaction. We've seen it on the material that's already been served in this case. We've seen it in the submissions of junior counsel for the prosecution, who's told us already that the pre-trial brief is going to have to be revised so as to lift some of the redactions that were initially implemented. We will see this again and again in the pre-trial process if we adopt that process. I'm not suggesting that it wasn't appropriate in the Mustafa case. I'm not suggesting that it cannot be adapted as a starting point in this case, because for proportionality reasons, given the huge volume of material here, one can well understand why it would be impracticable to make individual prejudicial determinations in advance of each redaction. But what we all have to recognize squarely is that if that is the case, what we will start with is material which has been vastly over-redacted, which makes it extremely difficult for the defense to comprehend the detail in certain instances, and which will require a vigorous and muscular process whereby the pretrial chamber considers defense applications for de-redaction in the interests of justice. And as I said earlier on, there is a danger that that process, with a reluctant prosecution, and so far the signs of the prosecution's commitment to the underlying principles of fair trial are not encouraging, that there is a danger that it becomes a process of pulling teeth and is slow and resisted. And I'm simply making that point on the record now, because as you see, my position throughout is we'll see how this works out. But I'm not seeing any positive signs at the moment that the prosecution is genuinely committed to a carefully calibrated redaction process, which genuinely is designed and implemented in a manner best aimed at achieving the interests of justice. And of course, as I've said at the outset of the Mr. Vasili's first appearance, the defendants have nothing to fear in this case from the truth. But what is a danger is a situation where unnecessary redactions make a full investigation of the truth impossible. So yes, by all means start that way, but I predict here and now that will result in a great deal of inter partes litigation in the meantime, unless the prosecution shows a marked change in attitude. Those are my submissions.
Thank you very much, Mr. Emerson. Before giving the floor to Mr. Young, just one small point. I think Ms. Lawson is not a junior counsel of the prosecution. She's a counsel for the prosecution. So I think we should avoid using this term when we refer to the different teams, if you don't mind. Mr. Young, please.
Your Honour, thank you. Just very briefly, Your Honour will know that in our submissions in relation to the redaction regime from paragraphs 37 through to 42, we did express some legitimate concerns about the adoption of the Mustafa procedure. And the way we put it to summarise the position is that if there was an adoption of the Mustafa procedure, it would effectively shift the burden from the SPO to prove the necessity of redactions as an exception to the general principle of full disclosure onto the defence to seek to lift redactions that have already been imposed by the SPO with no judicial oversight. And we maintain and stand by that position.
Thank you, Mr. Young. Ms. Alejandra.
Your Honor, we do not oppose the redaction regime in the Mustafa case. And whilst I say that, I do also wish to endorse the views of Mr. Emerson taken earlier. Thank you.
Thank you, Ms. Alejandra. Ms. Lawson, do you have anything to add or to reply to what has been said?
Hopefully it will be reassuring to Council to know that none of the materials they have received to date have been redacted under this particular regime. Nothing further. Thank you.
Thank you very much. Unless any of the Council has anything specific to say on this matter, I will move to the last topic, which is any other matter. At this point, I would like to ask the parties whether they have any other issues they would like to raise, and I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures may be taken. I turn to the prosecution.
Nothing further from the prosecution. Thank you, Your Honor.
Thank you. Mr. Hooper.
Yes. Well, the matter is a very important matter concerning Mr. Thaci's continued detention. I think at the initial appearance last week, we made it very plain that we did not accept for one moment that the necessary criteria for his being detained, found in Article 41, were satisfied, and that it was our intention in those circumstances to apply for his interim release. And we also suggested, or I also suggested last week, the modalities, as it were, in which that exercise should be conducted. Now, we've the first matter, of course, is that we need to have full disclosure of those arguments that have been placed before Your Honour to justify the use of an arrest warrant as opposed to a summons in his case. And I've received from the prosecution a redacted version of the SBO request for an arrest warrant. I must say, looking at the face of that document, there are some strange redactions. In their paragraph 2, for example, we have a reference to, and I'll just read it, having regard to articles, redacted, of the laws and rules, redacted. Now, I don't know what process of supervision of those redactions took place, but that clearly can't be justified. And not only that, but also there's references clearly to some behavior or alleged misbehavior of Mr. Thaci in the course of that document, which itself is redacted. And we will understand, of course, that witnesses' names and complainants and the like, if they figure, should and may have their names redacted if that's necessary. But we'd ask the prosecution to reconsider their redactions and to let us have a less redacted version of that, and also to ensure that all the evidence that's quoted in the footnotes to the SPO request for that warrant is served on us within as soon as possible, and not later, because it's available to them than 3 days. Now, once we have that material, and I think having spoken to Mr. Emerson earlier this week on this matter, I think we're suggesting a similar scheme, and perhaps together with my learned friends as well, that the way forward for each accused, and they're not a job lot, even though the prosecution in their filing, I see, try to treat them as such. They're not a job lot. Individual applications will be made, and we suggest that the appropriate modality is that once we're fully informed, not only of those matters that the prosecution laid before Your Honour to justify the warrant, but also any additional matters that they'd wish to raise in the course of the debate before Your Honour, that those be disclosed to us, can be by way of perhaps a filing or whatever on the part of the prosecution to which we can respond, but that at the end of the day, the matter in fact has the benefit of an oral application. Now, as for the date of that oral application, I'm not suggesting a date today, because we'll come before the court, if I may say so, when we're fully prepared, and with the agreement of Your Honour, and of course when is suitable. So that's the only matter, in fact, I'd wish to raise in respect of that matter. And I suppose today would be asking Your Honour, if not today, in the very near future, if Your Honour can in fact adopt and agree those modalities. Thank you.
Thank you, Mr. Hooper. In any case, I think before making any decision on this matter, I will need you to file an application, and then the question of an oral hearing will be dealt with. But first of all, it's up to the defense team to file an application in that regard for interim release.
Well, Your Honour, the process that has been undergone so far is, of course, that that Mr. Thaci was arrested on an arrest warrant as a consequence of matters that were raised before Your Honour. And in respect of that, of course, the defence had no say. Your Honour hasn't heard, in fact, the arguments from the defence. And I'd submit as a simple rule of audi partem that Your Honour is in fact entitled, in fact, to hear from both sides. Your Honour's heard from the prosecution. All I'm saying is, by all means, give them room, as it were, to include further matters, so that the defence, the applicant, is fully aware of what arguments he has to face. This seems entirely fair and entirely in line with other jurisdictions. And then we come before Your Honour and make our application, our formal application. So I could make an application to Your Honour to say, would Your Honour in fact accept these particular modalities, i.e. that we hear the full argument from the prosecution, if there's any additional matters to those that they presented to Your Honour in the course of the application for the warrant. And then we respond to that. We don't mind exchanging submissions in paper in order to assist and focus the parties on the issues that matter and to assist Your Honour. But should it really be our application at this stage? I ask that somewhat rhetorically, but should it? Because the prosecution have already laid these matters before Your Honour. All we're asking is for us to be invested with that full knowledge, in addition to any other matters they want to raise. Then we can make our application fully informed. That would be a simple and fair way of going forward. Otherwise, Your Honour, we become, as it were, the protagonists in this system. And effectively, given that the rules themselves, and indeed the law of this particular court, makes it plain that in fact detention is an exception, and that indeed release is presumed in the absence of the criterion being fulfilled, and then it's my submission that that would be the most appropriate way of going about it. We get informed, we respond, and Your Honour decides.
Thank you, Mr. Hopper. I think you said a very important point, which I agree, is that I need to be briefed from both sides, from the prosecution, but also from the defense. And now the party that I haven't heard on that issue is the defense. This is why I think it's perfectly appropriate that you file an application, then the SPO replies, and you can of course reply as much as you want after that, and more if needed. And I said I didn't close the door to an early hearing at all on that issue, because I think the more discussion there can be between the parties and the more I'm informed, the better. But it seems to me appropriate with a legal framework that you first file an application for interim release to trigger this process. Unless the prosecution wants to say something specific about this, I will give the floor to Mr. Emerson, but Ms. Lawson.
I'm happy to respond after each counsel have made their submissions. Thank you.
I've just been told that, Mr. Hooper, I think you said something, but your microphone was off. So if I can ask you just to repeat what you said. Thank you very much. And sorry for this. Your microphone is off at the moment, Mr. Hooper, so we cannot hear you.
I see.
Yes, now it's fine.
Now I say you
Please,
don't want the whole lot again. You just want. I think the last remarks I made were merely. That's all I've got to say, and thank you. At least I hope that's what was missed. Okay, thank you.
I think so. Thank you, Mr. Hooper. Mr. Emerson.
Your Honour, there are some slight differences of nuance between myself and Mr. Hooper, although perhaps not any great differences of substance. First of all, unlike Mr. Thaci, the prosecution did hear representations on behalf of Mr. Vasili before deciding on the mode that he should be brought before the tribunal. Some weeks before the process began, I wrote to Mr. Smith making detailed representations as to why Mr. Vasili should be trusted to surrender if his attendance was required and the indictment was confirmed, rather than being arrested at home, as I know some of the other accused were. And I'm pleased to say that that iterative process resulted in an arrangement for him to surrender by consent, which was honoured by both sides in a collaborative manner, so that he was notified in advance of the time at which he should surrender, and he did so, which will have been clear to all concerned was a strong signal and indication of his commitment through me to cooperate with the tribunal so that provisional release would inevitably be granted in due course. And so I trust that it was never made clear to me whether that letter was shown to you, and I'm not asking you to indicate whether it was or it wasn't. Because the prosecution itself, as a result of that, entered into negotiations with me for the voluntary surrender of Mr. Vasili. So to that extent, we are on to a collaborative, a cooperative start of a process which we trust will result in Mr. Vasili's a provisional release on suitable terms to guarantee his attendance and to give the court such reassurance as it considers necessary. As far as the procedure is concerned, I am, of course, entirely in your hands as to the order of written submissions and the manner in which you would find them most useful. That said, you have before you today a formal application from Mr. Vasili in writing. You will find that at paragraph 15 of our submission for today's hearing, which, if you thought it appropriate, could be treated as the application for the purposes of triggering an exchange of written pleadings. And you will see the way in which it is formulated. Mr. Vasili formally applies for provisional release pending trial and invites the pre-trial judge to fix a timetable for the exchange of written submissions to be followed by a short oral hearing, unless he, that is you, is minded to grant provisional release on conditions on the basis of written submissions alone. So the proposal is put forward in this way, simply to give you the maximum degree of flexibility if you wished to treat this application as the triggering event, and then to put the prosecution in on notice of its obligation to outline its objections to provisional release. Now, I understand that Mr. Thaci's counsel's approach in relation to the grounds for arrest and so forth, but that is a different question in any event from the question of provisional release. I mean, of course, there will be many issues that are in common, but it's a different framework. You have now the accused before you. You have a legal framework within which to make the decision. And that legal framework provides not just in the law itself, but also in the overriding provisions of Article 5 of the European Convention on Human Rights, that there is a strong presumption in favor of provisional release pending trial for an accused presumed innocent, and that the burden of justifying, this is the point, I think, the legal burden of justifying pre-trial detention rests squarely on the prosecution. And it's one that can only be discharged by reference to specific and identified considerations, not in general or of a generalized character about Kosovo, but relating to the particular accused whose case you are considering, and requiring the prosecution to establish precisely how any particular risk it relies on would be prevented by holding the accused in custody for the duration of these proceedings, which are likely to be 4 or 5 years, despite a faithful application of the presumption of innocence. So we're in this situation. It's not really a question of looking at what the grounds were for arrest of Mr. Thaci, or indeed for the voluntary surrender of Mr. Vasili that was negotiated in advance. The question now is a new question, which is, should the court grant pre-trial release? Now, we will file an application separately, in addition to the formal application that we filed today, if you consider that necessary, but it will be thin, because all it needs to say is that Mr. Vasili applies for provisional release. It's a formality, because the burden then inevitably, legally, shifts to the prosecution, and the real thrust of the debate will take place when the defense responds to the prosecution objections. So by requiring another stage in the process, in addition to that, at this stage at the outset, one is simply delaying the process, because there won't be anything very much in it other than a formal application, which in any event has been made in writing in advance by Mr. Vasili in these proceedings, in the document you received last night. So those are our submissions.
Thank you very much, Mr. Emerson. Would it be complicated for you to file a specific filing on this issue, if you don't mind? And I say that it's really not to slow down the proceedings or to not to be expeditious, but for, I think, for the purpose of clarifying which decision we have to take, which procedure it is within the proceedings. I think it would make things easier, if you don't mind.
I will certainly do that, and I can do that in very short order. But may I say now, and if anyone objects to this on the other side, or indeed if you consider it inappropriate, please tell me now. The application will simply say that Mr. Vasili is applying for provisional release under the relevant provisions. So you'll have it within a very short time, and then the process effectively can begin of the prosecution justifying its position if it objects. I understand, because I've made inquiries already, that the prosecution has taken a default position of objection without, it seems, giving very serious consideration to the position, but we will see the way in which the prosecution articulates it on an individualized basis. But that will be the effective moment when meaningful arguments are put forward. So my proposal is, yes, of course, I will oblige by putting in a formal application, but it won't say anything in substance unless you direct me otherwise. Than that which you will find in paragraph 15 of the note for today's hearing, and that will then keep the proceedings orderly. But if that's not an acceptable process, please tell me now.
Thank you, Mr. Emerson. Duly noted, and I think we will start from there. Mr. Young.
Your Honour, very briefly, let me indicate that as soon as it is possible, an application will be made for Mr. Salimi's preliminary or provisional release. Once Your Honour is in possession of the full facts in relation to his situation, it will, we suggest, become very clear that, contrary to the narrative you have evidently been given, that he should be given provisional release. Your Honour, Mr. Salimi is a man of integrity who honours his obligations. Not only did he voluntarily cooperate when informed about a confirmed indictment, when asked to attend The Hague on the 5th of November, he was there. He cooperated, and he voluntarily took the course that has led him to be here in detention. But it wasn't only then, on the 5th of November, last week, that he voluntarily cooperated when asked to attend The Hague. Your Honour may or may not know that previously he was invited to attend The Hague in 2019, and again he voluntarily attended The Hague. And so, with respect to the prosecution, for the prosecution to seriously suggest, as appears to be the case, that he is a flight risk is absurd and frankly ridiculous. We will be urgently seeking from the prosecution in the next few days any disclosure which relates directly to Mr. Salimi's previous attendance in The Hague, his previous cooperation, his previous engagement with the authorities, which may shed light on his cooperation, because Your Honour may think that's directly relevant to the issues that you will have to consider, because we want to apply as quickly as we can. But as Mr. Hooper said, we want to make sure the application is properly prepared so that a fair judgment can be made on the merits. Thank you.
Thank you very much, Mr. Young. Ms. Alexandra.
Your Honor, we will be submitting a written application for provisional release, but what I want to say at this stage is that Mr. Krasniqi was not given an opportunity to surrender. He would have, as he did when he was previously summoned to attend in The Hague, and he did attend voluntarily. So we will put our written application in and wait to hear what the prosecution has to say in response. Thank you.
Thank you, Ms. Allegara. I see Mr. Hooper asks for the floor. Mr. Hooper.
Well, Your Honour well knows that Mr. Thaci not only resigned as President of Kosovo in order to cooperate with the court, but also surrendered himself on a voluntary basis to the authorities in Kosovo, and was thereafter brought to the Hague. In terms of the application itself, of course, I've had the benefit of the discussion between Your Honour and Mr. Emerson, his proposals, and Your Honour's views. And similarly, we will undertake, probably today, to put in, as it were, a naked application for Mr. Thatcher's interim release with or without such conditions as the court requires. And we do so in the expectation that that will be responded to by the prosecution to address his personal circumstances and their arguments in respect of Mr. Thaci, and that Mr. Thaci or the defence will then respond to that with a view, of course, to having an oral discussion, further submissions if necessary, before Your Honour. So that's my understanding. I hope I've read between the lines accurately, and that's the position. Thank you.
Thank you, Mr. Hooper. I don't think it's up to me to tell you what you have to include or not in any request. So I will then wait for the filings in due course. Ms. Lawson, do you want to reply to what has been said by the 4 defense teams?
Yes, thank you, Your Honour. In relation to the application for the arrest warrants itself, redactions which were applied were carefully considered and were required to protect individual witnesses or other confidential information. Additionally, to suggest that the prosecution treated the accused as a job lot, as was done, is a misrepresentation of the submissions we made. With regard to the material referenced in that application, as we advised each of the council by email on Monday, a package of those materials is being prepared with a view to providing it this week. Regarding the substance and process, each of the accused are currently detained on remand pursuant to a judicial decision. It is the SPO's position that there are no circumstances warranting a change in that. Should any of the defence teams wish to challenge that position, either for provisional release or otherwise, Rule 57 provides a clear procedure and framework for doing so. We do object to the proposition that the defense teams will file a cursory, or I think Mr. Hooper described it as naked submission. There are many matters which can usefully be briefed and decided solely by way of oral hearing, but in this instance, detention is not one of them. The parties' submissions are likely to involve detailed legal and evidentiary points. Therefore, in the event that the defense teams wish to challenge detention, written briefing will be appropriate, and the parties should submit fulsome briefs detailing all of their arguments so that Your Honour is fully apprised of the relevant circumstances. And should Your Honour then consider an oral hearing to be useful, having reviewed the written submissions, the SPO is certainly not opposed to that. Thank you.
Thank you, Ms. Lawson. Mr. Emerson, you ask for the floor.
Before Mr. Hooper replies, it seems that there may have been some misunderstanding on Ms. Lawson's part as to what was being proposed. The suggestion is not that there should be a naked or bare application followed by an oral hearing. The suggestion is that that application would be put in that form simply to trigger the exchange of written pleadings. But because the burden is on the prosecution, their substantive written pleading should go first so that the defense knows the case it has to meet. Otherwise, we're making an application blind without knowing what the prosecution is relying on. I mean, an ordinary common sense default position here is that these men should be released today. That is the presumption. It's not true to say that there is a presumption in favor of their continued detention. There is no presumption in favor of their continued detention. They are before the court today. The presumption is in favor of their release. Now, you have asked us to indicate that to file for procedural reasons a separate document asserting that they should be released, so that the prosecution then can reply to that and put its objections. And it's at that stage that the detailed factual and legal submissions that Ms. Lawson refers to would first be made by the prosecution and then responded to in reply by the defense. What Ms. Lawson is trying to achieve is a situation where the defense put all of their cards on the table at the outset. The prosecution then replies to them. Our suggestion is that in whatever the form of the process, and I'm entirely happy to go with Your Honour's suggestion, the substance of the process is unquestionably a matter of law. The burden is on the prosecution. So if that is the case, then we must have the last word. And if we have the last word, we must have that after we know what the objections are. In the case of Mr. Vasili and Mr. Thaci, the prosecutor broke the rules. We all know that. The prosecutor made a public statement in June in flagrant violation of the rules on the confidentiality of unconfirmed indictments to announce that he had filed an indictment before you against Mr. Thaci and Mr. Vasili at that time with a large number of other co-defendants. It seems that their cases were not confirmed, but only in respect of the 4 defendants in front of you today. Those rules were broken very clearly, and the consequence of that is that the 2 accused, Mr. Vasili and Mr. Thaci, have known since June that they were the subject of an indictment. Now, in those circumstances, for the prosecution to be saying that it is up to them to outline their defense case in relation to a provisional release before the prosecution responds, in our submission, is wrong in substance, wrong in principle. Entirely happy to maintain procedural orderliness, to have a separate application filed, but it need do no more than assert their rights to provisional release. The burden then is on the prosecution. And in our submission, that is the way in which it should be dealt with. And the reason I've intervened now is Miss Lawson responded to a suggestion that wasn't being made. And so she obviously needs the right to respond to the suggestion that was being made. And I hope she now understands what that is.
Thank you, Mr. Emerson. Mr. Hooper, do you wish to take the floor?
No, we agree with that procedure. It's the fairest procedure and the right procedure to follow.
Ms. Lawson, do you have anything to add?
Yes, thank you, Your Honour. It is not the case that the defence would be making their submissions blind or without knowing what the prosecution is relying upon. We have already disclosed the application on which the arrest warrant was based, which forms the basis for the judicial decision that is in place. Further, as counsel for Mr. Vasselli indicated, what is important for the defence is to have the last word. We have no objection whatsoever to that, and in fact the appropriate procedure in order for that to occur is for the defence to make their substantive application, including all relevant details, for the prosecution to reply, and for the prosecution to respond, and for the defence to reply to that, and if necessary, further oral hearings to be heard. Thank you.
Thank you, Ms. Lawson. Mr. Emerson.
Yes. Again, it seems to be a fundamental misunderstanding on the prosecution side. The position when the prosecution broke the rules and announced the existence of what was confidential information, namely that there was an unconfirmed indictment present before the pretrial judge, they added, as a justification, Mr. Smith added in his public statement, as a justification for breaking the rules, that he wished to make it public because an attempt was being made by Mr. Vasselli and Mr. Thaci to, quotes, derail the proceedings, unquotes, with no explanation and no particulars given. As Mr. Hooper has explained, that information has been redacted from the arrest warrant information that's been provided. Now, it's self-evident to anybody with any common sense that there is no conceivable objection to the grant of provisional release against any of these accused, certainly against Mr. Thaci and Mr. Vasselli, as regards non-appearance. That is simply not going to be an issue. The question is whether or not the prosecution has real identifiable grounds for alleging that if they are not detained in custody, those two defendants will themselves personally interfere with the course of justice. That is the only possible basis that the prosecution could put forward. The essence of that was mentioned by the prosecutor in his statement when violating the rules in June. And it was mentioned in the material that has been provided to us in a redacted form in a way in which it's completely incomprehensible. In neither situation have we been given the gist of the real reason why it is said that we should remain in custody. Now, let's cut away the brush and look at the real issues here. Non-attendance, flight risk just does not exist. So the only question, the only possible issue is what it is that the prosecution says was an unlawful interference with the course of justice, justifying the conclusion that continued detention is necessary to prevent the two accused personally from interfering with witnesses. A rather unlikely proposition, but nonetheless, that is the case that the prosecution has to raise in order to have any possible basis for objecting to continued to release pending trial. They have withheld that information from us. So how on earth can we file a meaningful brief? So I mean, I'm sorry, but this is game playing again by a prosecution that does not seem very interested in achieving a fair procedure in the interests of justice. And Mr. Smith, who I see has absented himself from these proceedings at this crucial moment, is responsible for part of that. These decisions go to the top. So as far as the defense of Mr. Vasselli is concerned, we will be filing a bare application and the prosecution will need to respond to it in a manner that articulates realistically and in a detailed fashion the reasons why it says that for a 4 to 5 year trial, Mr. Vasselli should remain in custody despite being presumed innocent in circumstances where there is not the slightest evidence or even possibility of flight risk, being a
Mr. Emerson, I think we already stepping in the discussion on the application that you're going to trigger. So,
not really, because not really, because the prosecution has just suggested to you that the defence must file a detailed brief including all the material on which it relies. Well, on the crucial issue, it doesn't know what the objection is. That's why the prosecution. This is not treading into the substance. This is pointing out the utter lack of regard for fair procedure that Ms. Lawson, Mr. Smith, and Mr. Teager are urging upon you.
thank you, Mr. Emerson. Unless any of the parties have anything to say on that issue, we will now move into the... no, Ms. Lawson.
Yes, thank you, Your Honour. I had been intending to let it pass, but given that counsel for Mr. Vasselli repeated his allegation that the SPO broke the rules, I would like to make very clear that that was not the case, and that any steps the SPO took were taken with appropriate authorization. Secondly, the application for the flag that Mr. Emerson has just been waving is a false flag. The application for the arrest warrant, as provided to each of the defence counsel, provides more than ample grounds to justify the continuing detention of each of the accused. Thank you.
I'm sorry to interrupt.
Mr. Emerson, very, very concisely, please.
I will, and I'm responding. I'm not raising a new issue. Ms. Lawson has just responded publicly and on the record to my accusation of unlawfulness in the conduct of Mr. Smith in June by asserting that the conduct was not in breach of the rules because it was conducted with appropriate authority. The statement of that kind cannot be left to go unremarked. Appropriate authority of whom? Was it a judicial authority? Was it an executive authority? And on what basis was it made? Because the rules are pretty clear. So if somebody in the system is adopting a power to arrogate to themselves an abridgment of the rules, then the defence are entitled to know who that person is and on what basis that abridgment was made.
Thank you, Mr. Emerson. Does any party has anything to say on this? Ms. Lawson? Okay. I would now like to ask the parties on their views for a suitable date for the next status conference. I note in that regard that counsel of the accused can participate via video conference. For the next VTC, if you ask for a video conference, I would kindly ask you to inform the registry 24 hours in advance so that we can take appropriate measures to organize the connections. And I also remind all the defense team that such notice should include the written consent of the accused. Organizing a video conference with several accused and counsel remotely involves a lot of preparation for the registry, so I kindly ask the parties to respect this process for the next status conference. Can I ask the parties for their views on the date for the next status conference? Ms. Lawson, please.
Your Honour, we have no particular submissions on that. As you are aware, we are fulfilling onerous disclosure obligations at the moment, but we are nonetheless available at the court's convenience. Thank you.
Thank you, Ms. Lawson. Mr. Hooper. Mr. Hooper, your microphone, please. Mr. Hooper, your microphone is off.
Well, I suppose it very much depends on the objectives that Your Honour feels should be met or discussed to justify a further status conference. But I hesitate to put a date on that. But I'd have thought sometime in mid-December.
Thank you, Mr. Hooper. Mr. Emerson.
At mid-December for a status conference sounds sensible, but I would not want that to be thought that mid-December was the appropriate date for any oral hearing of a provisional release application, which may well be before then.
Thank you, Mr. Emerson. Mr. Young.
Mid-December sounds entirely reasonable.
Thank you, Mr. Young. Ms. Allegendra.
December, Your Honours, is suitable and reasonable, aside from the application for provisional release that we intend to submit.
I am told that my microphone was off. Before we end this hearing, I just want to inform the parties that when asked for any submission on any topic or proprio motu, counsel are at liberty to make joint common filings if they so wish. This concludes today's public hearing. I want to thank the interpreters, the stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.